There's an ancient concept in international law called international servitude. It doesn't mean what you're probably thinking. The idea is that it is open to a sovereign nation to limit its sovereignty by granting sovereign rights over its own territory to another nation. This was inherent in the old idea of a vassal state or tributary state, where the subservient state remained intact with its own government, but the dominant state was granted certain powers and privileges. For instance, in 1898, China granted to Great Britain a 99-year lease over the island of Hong Kong. The island remained Chinese, but China gave up many of the powers we normally associate with sovereignty. The idea of international servitude, though, is now mostly an artefact of history. In 1818, the United States and Great Britain concluded a treaty, part of which related to the use of the North Atlantic coastal fisheries off the coast of Newfoundland in what is now Canada, but which was then British North America. The provision said, in part, that the inhabitants of the United States shall have forever, in common with the subjects of His Britannic Majesty, the liberty to take fish of every kind on the southern coast of Newfoundland. Towards the end of the 19th century, Great Britain started to impose regulations on fishing in that area of coast. The regulations were merely for the protection of the fishery, and they weren't a surreptitious attempt to throw the Americans out. However, the Americans didn't like the regulation. They argued that the Treaty of 1818 created an international servitude, by which Great Britain agreed that it could no longer exercise full sovereign rights over that area of coast. Great Britain disagreed, maintaining that it retained those sovereign rights, including the right of regulation, and was merely bound by the treaty in the execution of those rights. The arbitrators said a provision which would limit the exercise of sovereignty of a state within the limits of its own territory can be drawn only on the ground of express stipulation and not by implication from stipulations concerning a different subject matter. In other words, it remains possible for countries to enter into international servitude, making a treaty which involves giving up part of their sovereignty, but this would be unusual and dramatic, so it would have to be very clear on the face of the treaty.